name is Megan Carling. I'm a solicitor in the family team, and the team deals with all ranges of inquiries across family law, so that extends to divorces, separations, contact arrangements, and we have been specialising particularly recently in adoptions and have seen a rise in inquiries in relation to surrogacy arrangements. So in terms of Scots law, if you're looking to buy a property with your partner and you're not married to one another, you would be deemed to be cohabitants. And it's definitely beneficial if you are buying a property and contributing unequal amounts to the deposit to consider getting a written agreement drawn up. The written agreement itself will be prepared by a solicitor and can detail the level of the detail that you want it to. For example, if one party is going to be contributing slightly higher amounts, that is beneficial because in the event of separation, if there is not an agreement in place that regulates how the equity is to be distributed, then the default position would be in terms of the title, which would mean that the equity would be split 50-50 between each party, and there would be no recognition of the unequal contributions to the deposit. There are mechanisms that you can use in terms of the legislation to recover those sums, but unless you can do that by agreement, you would need to seek to rely upon a court to have account taken of that. If you've already moved in together, it's absolutely not too late. You can have an agreement prepared prior to moving in together, or you can do it after you've moved in together. The point to bear in mind, though, is that after you have moved in together, there is a change to the circumstances in terms of both parties might not want to. The financially weaker party may not at that point want to enter into the agreement because it may not be of any benefit to them. So it's definitely better to think about it prior to moving in, because then there is more leverage to be applied essentially. There's no such thing as common law man and wife under Scots law. If you are living together, you are deemed to be a cohabitant. The legislation is the Family Law Scotland Act 2006, and there is no provision for common law husband and wife. It's something that's no longer a provision in Scots law, and the legislation regulates how cohabitants, what rights they have under the legislation, but there is no such thing as a common law husband and wife. If you do choose to get married, the agreement will still remain in place and can be relied upon in the event of eventual separation in the context of a divorce. But it is always recommended, if there are any significant changes to your lifestyle, for example, getting married, then a fresh agreement should be prepared and entered into. That's what's commonly referred to as a prenuptial agreement if that is entered into before the marriage, or a postnuptial agreement after the event of the marriage. But that does not extinguish the cohabitation agreement. That can still remain in place. It is usually about a property, so in the event that property is still there, it can still be relied upon when that comes to selling or at the point of divorce. If you're a step-parent and looking to adopt your stepchild, the first step would be to get in touch with your local authority. They would very much be involved in the kind of behind-the-scenes work before we would become involved in considering whether or not an adoption petition would be suitable. The local authority would then prepare the background report to advise whether or not they deem that that would be suitable for the child, and the outcome of that report would then be provided to us in the context of the court proceedings for the adoption itself. It depends. If the adoption petition is uncontested, then it can generally be over relatively quickly. There are certain procedures that require to be followed, but if the adoption is undefended, then that can be over within a matter of 6 months. The process in terms of you're a step-parent or not is exactly the same. The local authority would prepare a background report and they would provide that to the intended parents to determine whether or not they would be in support of the application. Us as lawyers would become involved at that stage, and we would go through the terms of the report with you to then consider the drafting of the adoption petition, which is the document that requires to instigate the court proceedings. The procedure thereafter is generally quite straightforward. There would be the appointment of an independent lawyer to go out, who's called a curator ad litem. They would go out to speak to the relevant people who would be involved in the adoption petition, and it would be their duty to report back to the court on whether or not they think the granting of the adoption order would be in the child's best interests. And if a child is over 12, then their consent is required for the adoption to be granted. any child in Scotland can be adopted up to the age of 18, but if adoption proceedings are raised prior to a child turning 18, they can still be considered, so long as the proceedings are raised before the child reaches the age of 18.